Hey guys, today we're going to talk about how to set aside, which is cancel, a statutory demand if you dispute a statutory demand. As you have watched from the previous video on what is a statutory demand, it is basically a letter of demand under a prescribed form in the Bankruptcy Act, whereby you have to demand a sum of money and provide particulars of the debt owing, which has to be more than $15,000. And if the person who owes you money does not pay within 21 days, you can proceed with bankruptcy proceedings against him. So, if you receive a statutory demand and you disagree with the debt, you feel that it is not rightfully demanded from you, you have 14 days from service of the demand. That means when the statutory demand was served on you personally or left at your residential address. You have 14 days, very important, to get it set aside. In other words, when you receive a statutory demand, you should immediately look for a lawyer, or if you can do it yourself if you are adventurous, look for a lawyer to have it set aside. The lawyer will take out a summons, which is essentially a court application with the High Court. Bankruptcy proceedings are heard in the High Court. He will take out a summons for setting aside the statutory demand under Section 97 of the Bankruptcy Act. In the summons, which you can have a look over here, the lawyer will pray, which is essentially asking the court to do something, will pray that the statutory demand be set aside, which is cancelled. Costs for the setting aside of the statutory demand, which is basically legal costs, but you will not get the full amount that you pay your lawyer. So for example, if you pay your lawyer $5,000 to cancel the statutory demand, doesn't mean, and if you're successful, doesn't mean you'll get back $5,000. You probably get back half or 2/3 or even 1/3 of the $5,000. The summons will also usually ask the court to provide such other relief as the court thinks fit or just. So the summons has to be accompanied by an affidavit explaining the background facts of the loan or the debt, how the debt arises, and give full particulars of the debt. Common grounds for setting aside a statutory demand would include misrepresentation to enter into loan agreements, fraudulent misrepresentation, fraud. I've seen people alleging unconscionable interest rates. Sometimes they could ask the creditor to recover from other people, other guarantors. They could also set aside the statutory demand on the basis that the creditor, the person who is owed money, who issued the statutory demand, they can have it set aside on the basis that the creditor holds valuable security. What is security? Security is something of value that is used as collateral for the debt. Because if the creditor already holds security, some kind of collateral, for example, a charge over assets, then it is not fair to go after the debtor when he already has assets to seize. For example, it could be a house, it could be a car, it could be some other asset. The person who received the statutory demand and who is taking out the application to cancel the statutory demand is called the plaintiff. And the person who issued the statutory demand, that means the creditor, the person who is owed money, is called the defendant. So, the defendant who issued the statutory demand, after receiving the summons and affidavit, has to give a reply affidavit explaining his version of the events, why his demand for the repayment of the debt valid. He can rebut the allegations set out in the plaintiff's affidavit, giving reasons and attaching documents why it is the allegations are untrue and that he should be allowed to proceed with the bankruptcy application. I once had a client who asked me to issue a statutory demand, and when the plaintiff took out a summons to set aside or cancel the statutory demand, my client asked me, why does he have to issue a reply affidavit? Why can't I just go to the court hearing and make arguments? The simple answer is that under the rules of court, Evidence has to be given by way of affidavit, which are sworn statements. The affidavit has to list out facts relating to the dispute, which are then sworn in front of a commissioner of oaths. And the affidavit will also be accompanied by exhibits of documents such as invoices, receipts, emails, WhatsApp messages, agreements, to show why the defendant's bankruptcy application should proceed and should not be set aside. A lawyer cannot simply go to the bankruptcy hearing and produce documents and show them to the judge and try to make arguments without any affidavit, because all the supporting documents have to be exhibited into the sworn affidavit and before a commissioner of oaths, and then presented to the court as evidence under the rules of court. So, before the court hearing, where the judge will listen to arguments from both lawyers, both parties, the lawyers may prepare a bundle of authorities to support their position. Authorities are simply past legal cases to support their position why the statutory demand should be set aside. The other lawyer will cite authorities, legal cases, to show why the bankruptcy proceeding should proceed and the statutory demand should not be set aside. The lawyers may also provide written submissions, which are legal arguments, to buttress their arguments so that the judge can read the legal arguments made before listening to the oral arguments made by the lawyers. So at the day of the hearing, both lawyers will present oral arguments to the judge as to why it should be set aside, why it should not be set aside, and the judge usually gives a judgment on the same day and will award costs to the winning party, and depending on whose argument is stronger, he may cancel the statutory demand, or he may allow the statutory demand to stand and for the bankruptcy proceedings to proceed if the debtor does not repay the debt. If the statutory demand is set aside, the creditor cannot proceed with bankruptcy proceedings because there is a dispute of the facts relating to the debt owing, and therefore he has to proceed with a writ of summons. You can watch the link below on what is a writ of summons. Essentially, he has to go to court and let a judge determine the factual disputes, who is telling the truth and who is lying. If the creditor's lawyer manages to persuade the judge that the debt is a valid debt and there are no grounds for cancelling the statutory demand, then the debtor has to repay the debt, otherwise the creditor can proceed with bankruptcy proceedings, which I will talk about in a later video. So thanks for watching this video on setting aside a statutory demand.